Hello again, this is Otis Landerholm, and today I'm continuing the video series on how to file for a marriage-based green card. Today my plan is to talk more about the application process. In our first video we talked about green card eligibility, which includes three things. First, you have to be legally married. Second, you have to have been married in good faith. And third, you have to be quote-unquote admissible. If you have questions about any of those three, please go back and watch my previous video and you can clarify those issues. All right, in this second video, I really want to talk more about the application process and the paperwork and the evidence we need and all that stuff. So let's get to it. So there are two processes, just to throw it out there. One is called adjustment of status, and the second is called consular processing. An adjustment is you have to have entered the country lawfully with a visa or at least getting paroled into the United States. So you have to have entered lawfully, there are other eligibility requirements as well, but generally speaking, the idea of adjusting is you have your lawful status that you entered the country on, and now rather than going back to your home country, what you're going to do is just adjust. You're going to change from the one status that you entered the country on to lawful permanent residence to your green card. So you're doing that adjustment or whatever here on U.S. soil, and that allows you to not have to do the second process, which is your other option if you're not eligible for adjustment, and that is consular processing. Processing your green card through the U.S. consulate or the U.S. embassy in your country or your region of the world. Okay? All right, so let's talk about adjustments. Generally speaking, I and in my office, we do adjustments in 4 steps. Okay? So step 1 is the paperwork, which includes the petition. It includes the green card application, and it includes the application for work authorization. All of the paperwork, and we submit it. So step 2 is the submission. We mail it off to the government. We get a notice from the government saying that they've received the application. We get a notice for biometrics, so you go in and get your fingerprints taken, and then we get a notice for your interview. Step 3, of course, is the interview, where the officer will be asking you questions about your relationship and about your eligibility to adjust status. And then 4th is the decision. Okay, so step 1, the paperwork. Step 2, submission. Step 3, the interview. And step 4 is the decision. Generally speaking, the whole adjustment process takes about 5 months, 4 to 6 months generally. But they're running about 5 months, okay? At least in the San Francisco office, which is where I file most of my cases. The second process that we'll talk about is what's called consular processing. So consular processing is generally much slower, okay? Step 1 is the petition. Step 2, if the petition gets approved, you sort of have to wait for that approval, and then you can put together a waiver application if you need to waive a ground of inadmissibility, okay? And I like to do it then because I don't want you to be outside the country and having to put together a whole bunch of documents. I'd rather prepare the waiver before you need it. All right, so step 1, the petition. Step 2, the petition gets approved, okay? Step 3 is the waiver, if necessary. Step 4 is a consular interview. And step 5 is the decision, okay? If you don't need step 3, which is the waiver, then you go directly, of course, into the consular interview, and then you get a decision. Once that consular officer at the U.S. consulate overseas agrees with the case and grants your case, they'll put an immigrant visa in your passport, which will allow you to get on a plane and will allow you to cross through and sort of present yourself in front of U.S. Customs at the airport. And then as soon as you cross through Customs, you'll be admitted as a lawful permanent resident, and they'll mail you your green card. All right? So those are the two big separate processes. If you have specific questions about which is the best process for you in your situation, that's the perfect question to consult with an immigration lawyer about. Feel free to give my office a call. I'd be happy to discuss it with you. All right? So regarding the paperwork, each of these processes start with the petition. All right? So your U.S. citizen spouse is a U.S. citizen, and they have the right to file a petition for their non-citizen spouse to have them here in the United States with them. Okay, so the petition, we'll just talk about the paperwork that goes with that. There's basically 3 forms. Okay, the first is Form I-130, which is the petition itself. The second is Form G-325A, which is biographical information for you and your spouse. And the third is the Form G-28, which says who your attorney is going to be throughout the petitioning process. Okay? The evidence that goes along with the petition is basically your proof of your lawful marriage, your marriage certificate, your proof of the fact that your husband or wife is in fact a U.S. citizen or a green card holder, 1 photo from each of you, and then all of the evidence that you have, which feel free to call my office, we'll help get you a checklist of all of the quote-unquote bona fides of your marriage. You have to show that you have a good faith marriage. And so, these can be tax returns showing that you filed your taxes jointly. If you have kids together, of course, that's excellent evidence. So send the birth certificates of children. If you have joint ownership of a car, then submit joint ownership of the car. If you're both on insurance, even health insurance or whatever, we submit that. If you both have gym memberships in the same place, we've done that before. We basically brainstorm and we put together a whole list of all of the evidence that we have that says that you guys have a legitimate and, a legitimate marriage, right? There's also a filing fee with the I-130, and that's a fee to the U.S. government of $420. I'm recording this in the fall of 2014, and so, those rates could go up. You should check the instructions and make sure that the fee is still $420. You want that on a check or a money order made out to the U.S. Department of Homeland Security, and you put all that together, and that is your petition, all right? So, the green card application, as long as we're talking about adjustments, has forms and evidence as well. So the forms are the I-485, which is the green card application itself, the Form I-693, which is the medical evaluation, the Form I-864, which is the affidavit of support, and the G-28, which is again the notice of entry of appearance of attorney throughout the case. So along with the green card, which is all of those forms that I mentioned, you've got to show evidence that you entered the country lawfully. You've got to show evidence that you are quote-unquote admissible to the United States. You've got to show evidence of your financial support, which is generally 3 years of tax returns for your sponsor. Your sponsor has to be a U.S. citizen or a green card holder, so show evidence of that. And that is basically it to go along with the green card application. The third piece of paperwork is regards to the employment authorization. So that is on Form I-765, and again, I submit a G-28 with it. You need 2 photos to go along with it, and there's no additional fee. There is a fee with the green card application. It's $1,070, again, on a check or money order written out to the U.S. Department of Homeland Security. Okay, so that's a big long thing. Basically, if you don't want to worry about this, then feel free and consult with my office. We'll give you a checklist for the whole thing. We also give you a questionnaire that has you fill out all of the information that we need to populate every one of these forms, so you don't have to go through the process of downloading everything and making it all yourself. All right? So the paperwork for consular processing, remember there's 2 separate application processes. So the paperwork for consular processing first starts with the petition, which is exactly the same as the petition on the last for adjustment of status. So see that if you have it. And I'm going to have slides available for all of this, so you can see these slides. The second type of paperwork is for the waiver. And again, the waiver is, you'll only file it if you need it. And there are several different types of waivers. The two that I'm really talking about right now are the I-601 and the I-601A, which would be on those forms, and then the evidence with the waivers and the filing fee for the waivers to show the hardship to the U.S. citizen spouse, which is what you need to waive whatever ground of inadmissibility you may have. Then the third thing for consular processing is the green card application itself, which is done electronically on Form DS-260, and you upload everything through the Department of State, and then you also do your I-864 and G-28s and things like that, and you submit those when you go into your interview, if not by uploading them through the website. Okay, so and some of that depends on the particular consulate that you're appearing in front of as well. All right, so how do you apply? Basically, you complete all the forms correctly, you compile all the evidence in support of each of the applications correctly, you write a cover letter explaining your eligibility, you put all the application in order, you mail 2 whole copies of the application off, or sorry, you don't mail 2, you make 2 copies, one for your records, let me clarify that. In my office, we always make 2 copies of all of this. One for our file, one for you, for your records, and then the original application gets sent off to the government. And so then, yeah, you mail off everything, and then you go through the process. Okay, so that's basically all that I'm talking about in today's video. There are a couple of other things to keep in mind. First of all, some green cards, even if you've got one and even if you've won it, they do have limits. They have to be renewed, usually every 10 years. And you have to obey all laws, you have to pay taxes in the U.S., you have to maintain your residence in the United States, or you could lose your green card. All right. The other thing is that certain green cards come with conditions on them. If you just got married within the last 2 years and you're applying for a green card today, your green card will come with a 2-year conditional green card attached. It basically comes with a 2-year expiration date. So what that means is in 2 years, and really it's 90 days before the 2 years end, you have to file a separate form. It's called Form I-751, and it has to show that basically you still are married and you're still together. Or if the marriage ended, you have to show one of the qualifying reasons that the marriage ended. Basically it's a way to show that you didn't commit marriage fraud when you got your green card. Okay? So lawyers can definitely help you through this process, and my office is more than happy to help you through this process. The way we can help is by ensuring that all the forms are done properly, ensuring that all the evidence was put together properly, trying to make it so that we minimize the delays caused by what's called requests for evidence, which sometimes there's no way to avoid them. Sometimes they happen. But basically RFEs, or requests for evidence, can cause additional headaches to you if the government has to come back and keep asking you for more and more information. The other way lawyers can help is that we can represent you at the interview, which is generally true for adjustments only, not for the consular cases. But we can prepare you for them, we can represent you at them, and we can make sure that we keep a good record of what happened at that interview. And then fourth, we can take as many precautions as possible to ensure that your case goes smoothly, including, once you have a lawyer on the case, the government will send 2 copies of all mail, one to you and one to the lawyer directly. And so if for no other reason, it's a precaution to make sure that the government doesn't lose any mail, or to make sure that the mailman doesn't mess up on either your end or our end. Okay? So that's basically it. If you have questions about how to put your green card together, or whether or not you should apply, or what the best process is for you, feel free to call my office. I'd be more than happy to talk with you about that. And I hope that this was helpful. I know it was a whirlwind and we talked about it very quickly, but hopefully it was helpful. And yeah, if you have any feedback, just let me know. Let me know. And if you are looking for representation, obviously, feel free to call my office. I'd be happy to help. All right, take care.